questions about the Hub after the session, feel free to ask one of the house. Okay?
Thanks, Sarah.
I'm going to close this.
So, mine's Brenda. All right, good. So, I want to start by giving just a brief shout out to the Sigurd Housing Trust, because they have been funding our research into copyright, and it's always important to thank the funders for making this good work possible. And I want to begin with a question around the room, and this may be a little bit difficult for the lawyers to answer, but who here has violated copyright, or has been...
Who wants to admit they violated?
Well, who has been involved in a violation of copyright over the past week? And I'll put my hand up for that. And so, you know, setting aside file sharing, which is kind of a gray area in Canada, setting aside watching streams of TV shows or movies, which is probably illegal, and I'll ask next, who here has ever forwarded an email? So, technically, that could be argued that that's a violation of copyright. You could say that the consent is implicit by the person who sent you the email, that you're allowed to forward it on. But again, it's difficult to say for certain. So I think that, judging by the show of hands previously and the number of people that have forwarded emails and the complexity of those different relationships with the people who sent you those emails, it's very likely that everybody in this room has probably violated copyright. Probably in the last week, almost certainly in their lifetime. And the people in this room are not alone. As of January 2012, BitTorrent, which is the most popular file sharing protocol, claimed 150 million active users. And it's been estimated that between 98 and 99% of shared files on BitTorrent are being shared illegally. Traffic analysis of BitTorrent has also found illegal file sharing originating from IP addresses in the United States Department of Justice, Department of Homeland Security, the House of Representatives, the Federal Bureau of Investigation, and the German, Dutch, Spanish, and European parliaments. Similar research has also traced file sharing activity to IP addresses within the offices of Warner Brothers, Disney, Sony Pictures, Paramount Pictures, and 20th Century Fox. So when file sharing is originating from all these major content creators, it's not surprising that it's so difficult to stamp out. Industry estimates put the rate of piracy at 68% of all software sold in Russia, 82% of all music sold in Mexico, and 90% of movies sold in India. So this is, in all likelihood, the most widely ignored law in human history. And I'm going to argue that part of the reason for that is because it's drastically out of touch with the digital age. And I'm going to offer a few proposals for reform, which hopefully we can discuss based on the varying backgrounds that people are coming from. And I want to start by talking about intellectual property as a concept, which is relatively new. It only emerged in the it really only emerged in the last few hundred years and was properly codified in 1886 with the Berne Convention. The purpose of copyright is essentially to promote to promote expression, to promote artistic creation by incentivizing, monetizing the production of artistic works, and also to, in turn, help facilitate the rise of professional artists. Obviously, if you're going to be a professional content creator, you need a way to make money from what you're doing, and copyright is supposed to facilitate that. And in order to facilitate that, we grant creators with a monopoly, exclusive rights over their creations. And that's a limitation on freedom of expression, on what people can say in print. But we accept that because it's for the greater expressive good. With that in mind, I want to sort of re-examine the impact of copyright on artistic creation from a digital perspective. And one of the stories that I want to tell is about Adam Yauch. So when Adam Yauch passed away, Adam Yauch was a member of the Beastie Boys. When he passed away last year, there were a lot of tributes that said, you know, they don't make albums like that anymore. And the reason why they don't make albums like that is because legally it's a lot more difficult than when the Beastie Boys first started out. So when Paul's Boutique came out, which was their seminal album, came out in 1989, sampling was still a gray area. And the need for obtaining licenses for all your samples wasn't quite a settled matter of law. So the album, which had over 300 samples, didn't run into any problems. The following year, the law was clarified. There were two major cases. One was Vanilla Ice, Ice Ice Baby, which stole the bass line from Under Pressure, and the other was MC Hammer's Can't Touch This, which took the bass line from Rick James' Super Freak. Both of those resulted in huge payouts, and another case the following year where involving rapper Biz Markie, where he was enjoined from distributing an album that he produced. Basically sent a chill through the recording industry, and it really changed the terms under which record labels are willing to produce music. So right now they have very strict demands on obtaining licenses before they'll produce or distribute any music. And although the music industry is where these problems are most acute, it's not unique to that media. In 2010, a web developer named Andy Bio decided to commemorate the 50th anniversary of the release of Miles Davis's Kind of Blue by producing a chiptone version entitled Kind of Blue. I'll just play a quick clip for that for you. Mr. Bio was careful to obtain proper licensing for the use of the music, but he got into trouble for the cover art for the thing, which was an 8-bit rendering of the original photograph. This was a project that Mr. Bio had no personal financial stake in. He funded it through Kickstarter, and he distributed all the profits to the musicians. He just wanted to see it get done. But unfortunately, after the album was produced, he was contacted by Jay Meisel, the photographer of the original cover, demanding statutories up to $150,000 for each infringement, at the jury's discretion, and reasonable attorney's fees, or actual damages and all profits attributed to the product. So Bio, who again didn't make any money off of this, ended up settling for $32,000, essentially in order to avoid the legal fees associated with the case. Now there's, now some artists who work in violation of, and there's a quote from Mr. Bio on his website that I kind of want to read out. It breaks my heart that a project that I did for fun on the side and out of pure love and dedication to the source material ended up costing me so much, emotionally and financially. For me, the chilling effect is palpably real. I've felt irrationally skittish about publishing almost anything since this happened. Now, of course, not all artists who work in violation of copyright have run into these kinds of problems. Some of them have essentially gotten around this by not selling their product, by giving it away for free. Now, it's just as illegal to do that, but it's a lot more difficult. It makes it a lot less likely that you're going to get sued if there's no profits to seize. So, Girl Talk is an example of an artist who does that. DJ Danger Mouse is another, and I'll get to play one more clip of the Grey album. So this was a mashup of, does everyone here know what a mashup is? Yes? Everyone? No? Okay, well this was if you haven't seen this one. Sure, no problem. So this is a mashup that was released in 2006 that combines Jay-Z's The Black Album with the Beatles' The White Album with Music Consequences. So, Danger Mouse was contacted by lawyers from the Beatles once he released this, but there wasn't really much they could do because he was a student at the time. He didn't really have any money for them to take. They could have stopped him from distributing the album, except he had already released it on the internet, so there's really no way to shut it down. And obviously it's all over YouTube at the moment, and So essentially, artists can kind of get around the rules, and are getting around the rules by just releasing their product for free rather than commercially marketing it. But there's a sad irony to that, which is copyright law, having originally been conceived to spur artistic creation by guaranteeing a reasonable income for artists, is now forcing artists to release their work for free rather than selling it commercially. And one last example that I want to mention is just from a couple of months ago, on January 18th, 2013, which was the one-year anniversary of the successful anti-SOPA protests, which internet activists had declared to be the first ever Internet Freedom Day. It was supposed to be this year on January 18th. And in order to mark the event, an organization called Fight for the Future uploaded the iconic I Have a Dream speech, Martin Luther King's I Have a Dream speech, onto a video sharing website. However, as a result of a licensing agreement made between the King family and publishing giant EMI, the speech, along with all of Dr. King's other intellectual property, is under the company's control until the copyrights expire in 2038. So within 12 hours, the site was taken down after a copyright complaint. But of course, the outrage connected to that copyright complaint led to hundreds of other people to upload the video as a protest. And again, this is the realization that a seminal moment in the United States history is essentially owned by a private corporation, outraged a lot of people. The speech is of profound significance to people around the world who struggle against oppression, but particularly for millions of African Americans whose national and cultural identity and whose place in the United States was wrapped up in that speech. So there is something gravely wrong with the idea that it's viewed as a commercial product. And it's also a fundamental problem with copyright law in that, again, if you're talking about a legal regime whose purpose is to spur artistic creation, you can't tell me that if Dr. King didn't have copyright in that speech, he would have stayed home that day. There's no fathomable reason why copyright should have attached to that speech in the first place, and so certainly no reason why it should remain under restricted use until 2038. So those are just a few examples of sort of problems with the current copyright regime. And I want to propose three solutions in three areas of reform. One would be to switch from the current opt-out method of copyright to an opt-in method of copyright. The original reason why copyright was designed as an opt-out system was to spare artists from having to deal with all sorts of bureaucratic hurdles in order to register their work. But if you look at the development of certain tools that have made it very easy to opt out of the system, and I'm speaking specifically of Creative Commons, that could really be switched onto an opt-in system with very little impact on artists. If you just made it a free system, universally recognized, it would go a long way towards separating out all the meaningless copyright from the work that actually needs to be protected. The second reform that I would make would be with regard to term length. So the argument about term length, which in Canada is currently Life of the Artist plus 50 years, in the United States it's 70 years, in Mexico it's 100 years, the argument is about incentivization. And there's been consistent arguments to keep extending it, particularly in the United States, but also in Europe. And again, it's wrapped into incentivization. And of course, the obvious question is, if you're talking about people that died 50 years ago or 70 years ago, how are you actually incentivizing more production by extending copyright terms? Furthermore, the development of the internet has led to sort of a changing paradigm within the music industry. A survey of 5,000 musicians found that only 6% of their total revenue currently comes from recorded music sales. Additional 6% comes from songwriting and composing, but by far the largest slices come from live performance, teaching, and salaries as an employee. In the modern age, sort of the business model within the music industry has shifted quite a bit, meaning that I think that these sorts of protections are also serving more to stifle innovation than to actually foster content creation. And the third change that I wanted to propose is for derivative works, and that copyright law needs to recognize, first of all, that the digital age has led to a greater fluidity in the borrowing and adaptation that's central to the creative process. That being said, this isn't necessarily unique to the digital age. So The Taming of the Shrew, which is one of Shakespeare's most famous plays, about 30 years after The Taming of the Shrew came out, another play came out called The Tamer Tamed, and it involved the same characters where the wife who had been sort of, the husband who had sort of abused his wife, the wife dies, and in The Tamer Tamed, the husband marries a new wife, and the new wife uses the same tactics to sort of break him down. And it's sort of, it's exactly the kind of artistic dialogue that is central to the creative process, but it's of questionable legality today when you consider that a similar adaptation of Catcher in the Rye ran into huge legal problems when it was released 3 or 4 years ago. So I guess that's sort of my introduction to copyright and my summary of the problems that I see and the solutions that I see. And now I'd like to open it up, particularly because I know we have an interesting mix of people here between people involved in the content creation industry and the legal profession as well. I'm in the freedom of expression area, but that impacts everybody. And so I want to start by asking, well, first of all, about any general comments about anything that I've said, but also how people feel about how copyright impacts your lives today and your work. So hopefully we can throw it open and have a good discussion about that.
Well, I just want to kind of point out that if you had an opt-out or versus opt-in system, it doesn't really change the fact that Buddy, who created the 8-bit picture, you still would have been sued.
Sure.
Because
he would have been sued on that, but he would have been protected by creating a derivative work,
okay.
in my mind.
Okay.
I mean, these are to address 3 different aspects of the problem. The opt-out problem is, in my mind, connected to the opt-in and opt-out issue would be the fact that there's certain areas where copyright just shouldn't apply at all. So academic journals is one example. People were, after Aaron Swartz, who was one of the creators of Reddit, it was widely reported that he, it was all over the news that he committed suicide in the past few months. And people, a lot of people are blaming that on the draconian level of law enforcement in the United States. But there's also an ancillary question of why the reason why he was being prosecuted was because he had leaked a huge amount of academic journals onto the internet. And there's an ancillary question of, well, why were these protected by copyright in the first place? Again, if you took the copyright protection away, would academics stop producing papers? Of course not. It's their job to do so. You could say the same thing about legal memos, which, again, you do as part of your job. They're protected by copyright. Why are they protected by copyright? So that, to me, goes back to sort of an initial fundamental question about the purpose.
There's revenue from having to pay for access to those articles.
Sure. Sorry, I just realized I don't want to make this sort of a debate thing, so why don't we just throw it open and let people talk.
I mean, from a legal perspective, I think that all I can say is that a lot of the stuff that we end up producing in the office is covered by an entirely different sort of set of law, common law, really. So the fact that there's copyright attached to things that we may produce really doesn't matter. So it actually wouldn't make a difference at all if copyright law were obliterated. Maybe for certain things like giving talks, copyrighted presentations or things like that, but anything that we produce internally for clients is covered by solicitor-client privilege anyway, so it really wouldn't matter to us. And a lot of those, lawyers love taking the work of other lawyers and just tweaking it a little bit, and that's where legal precedent comes from, right? So the fact that, I think that copyright law is kind of ignored in the legal process anyway, and so it really wouldn't be a big deal to completely get rid of it. I don't think. What do you think, Daniel?
The problem I would have with an opt-in system is it's going to create it would just create a huge administrative headache to the international world of trying to maintain some sort of database of who's opted in, opposed to opting out. I'm a big fan of the Creative Commons type thing where people can choose to either allow their stuff to go out there in the world and be like, hey, what's mine is yours, or choosing the different levels of copyright protection you have. I think that's a fantastic way. And I agree that it is silly that some iconic speeches written by a president, or by a president, or by like, you know, a social advocate would be someone else's intellectual property control. But I think that almost, you know, it's inherent with copyright in the creation of things that you do own some protection to it, and that if you as an individual choose to make it available to whoever you want, that's more your prerogative, and you have to take the extra steps to
Sure.
make it available, or not to make it available.
Do you happen to know the history of the whole Martin Luther King speech? Like, so that was sold by the King estate to EMI?
So the King estate made a deal with EMI, basically selling the entirety of King's intellectual property produced.
Well, they're probably licensed.
License,
The
yeah.
copyright in that speech is in the recording of the speech, not the content of
Yeah,
the speech
it's
itself, correct?
Yeah.
So I mean, you know,
Well,
I
it
can
could be in the written,
no,
it could be,
the
if
speech-
you
no,
wrote
no,
the
no.
speech,
yeah,
then it would be in the written aspect of the speech as well as the recording of the speech.
sure, but you getting up and reciting the speech right now would be a violation of copyright, right?
Sure, but if I were to verbatim repeat his speech,
That'd be very impressive.
yeah, but
Good question, man.
it would violate the artist's right, the
Performance.
estate of the artist's right to perform.
Right.
So I'm wondering if this is like the equivalent of mechanical versus performance rights to music, right? And that's why I'm wondering when did this happen, you know, with EMI?
When did they license
Yeah, when
his?
did they license?
I'm not sure if it was done by him or by his estate.
I just wonder, because I mean, I remember back in the 80s, there were 2 or 3 situations where samples of that speech were used in music, like, I mean, actually, you used
Yep.
an extended version of that, okay. So now that's what we have.
Well, sampling it runs you into a bit of a different. It runs you into another problem because it depends on how much of the speech that you use and whether or not you've taken a substantial portion of it.
Okay.
Um,
Okay.
So that being said, the U.S. Has incredibly stringent laws on this, where it was forgive me, I can't remember the name of the song, but it was an NWA song that sampled, I think, in a half a second clip or a 2-second clip of a particular of an instrumental, like a classical instrumental song from years earlier, and the judge ruled that that was a substantial portion. So basically, in the state of the law in the U.S. now is that essentially any sampling at all, no matter how insignificant, should be licensed.
Yeah, there had been that kind of myth right at the 3 to 5 seconds when you were safe. And I know it's
And then, obviously that's just in the US and we're operating out of Canada, but the issue is, another issue, and this comes back to the digitization issue, is that with the internet, essentially everything is distributed everywhere. So the problem with having these different standards is if artists who are marketing their work broadly or putting their work out there online can be subject to whichever copyright law is harshest, with the lack of harmonization of different interpretations. So if you are a musician, I mean, unless you want to completely ignore distributing your work in the United States, you have to, no matter where you're operating from, you have to work under US law.
I have a relative who was in the entertainment business, and he was borrowing Dr. Seuss for years, very innocently and naively. He got a letter 3 or 4 years ago suggesting it would be high time to cease and desist,
Yeah.
which he did. But he just used it already. He was a young college student.
Yeah.
He didn't say he would not, could not.
One question I have is when you're talking about the incentive structure, and so let's say we're blanket recognizing that you can't really incentivize someone who's passed away to create more, so that's kind of a bottomed out argument. And I think you can also point to many areas of creation, such as fashion industry, tattoo artists that steal from each other in copious amounts and still can all make good livelihoods because it's more about a production basis rather than reaping benefits through licensing after the fact. You get paid to do something because you're putting your talent into it, not simply that you do it one time, let's say, and then continue to get benefits. So if that's a strong argument, I think, against copyright in general, I feel as though your other options of reform are more so saying we're going to try and take it down and kind of compartmentalize where we have copyright and where we don't. So I guess I'm just wondering, how would you overall distinguish from those areas, because the one thing, and we've spoken of this previously, I mentioned to you just at another time we met each other, was kind of that I see one of the things coming is more of a focus on production. So you crowdsource people, and they provide you funds to create something. But once you've created it, you really can't control it in this world anymore. After that, you can't expect to make any money from it inherently, based on how it's released. And so that works in some cases, but it might not work in others. So the examples I think of are LMAFO decided to sample Kanye West. They couldn't release the song, but they used it to become famous, and then as a result, they have access to working with all these other people and have built a career out of it. But they didn't expect to make any money from the very first song. So it really changes how people are expecting to make money, and I think copyright is still focused on that, license it and control it after the fact. So I really don't see how that, at least that one point of reform blends with the other two. I feel like that takes me almost all the way to saying we need full reform, copyright doesn't work anymore.
Sorry, which, well, first of all, you mentioned tattoo artists, which is an interesting point, because tattoo artists quite often work in contravention of copyright. If you've ever seen anybody with a tattoo of a cartoon character or a sports team's logo, and actually somebody pointed out to me that some countries' copyright restrictions allow any copyrighted material, any copyright infringing material to be seized and destroyed. So if you got a tattoo of, say, a Walt Disney character, I don't know what would happen to you. But I don't quite follow your, which was of the points did you say doesn't line up to?
Well, I guess I feel as though you're still saying that we should keep copyright in some areas, but if the idea behind copyright is there's this incentive to produce, and it doesn't really do that, what's the argument for keeping it at all?
So there is an argument that copyright should be more flexible based on the media and based on so a particular term length for films, a particular term length for television, a particular term length for music, a particular term length, depending on the nature and use of the material. The difficulty with that is it requires a really in-depth knowledge of the sort of market situation in terms of how much licensing and how much protection is really necessary for the artist's welfare and support, and how much is really just unnecessarily restricting further use and enjoyment of it. And so that it makes it a lot more complicated, where it's much simpler to have just one clear rule for everybody is the only issue. But there are strong arguments in favor of shifting copyright term length based on, and shifting protections around based on the media and intended use. In terms of the argument to keep copyright at all, there are people out there that make their living from copyright, from producing copyrighted works. So I've talked about a shift in the industry, but different business models are applied to different individuals. The industry as a whole, the music industry as a whole, is less dependent on recorded music and intellectual property protections to make their money than they were, say, 50 or 60 years ago. But at the same time, within the individuals, there are cases of people that do that. And beyond that, I mean, the question is really, I mean, what it comes down to at its heart is, if you view copyright law as a restriction on freedom of expression, which is fundamentally what it is, we are limiting the right of people to communicate certain ideas, to express certain ideas, but we do so in order to enhance the expressive landscape more broadly. If you view it that way, the question is, what is the legal formula that is best for freedom of expression? What is the legal formula that will provide the benefits that we want while restricting freedom of expression as little as possible? And so I think that saying that no copyright at all, I don't think that that's the proper formula. I think that copyright does promote freedom of expression to a degree. I just think that at the moment it's overly restrictive.
Okay.
I definitely agree that term lengths are way too long.
Yeah. I mean, that's, yeah.
I don't see the need for 50 years even. I think that's pushing too long. It's just, if you look at the history of the growth of the term length of copyright, when kind of our old Copyright Act, I think, started at 20 years.
Well, the Berne Convention was like the artist plus 50 years.
No, but in Canada.
Yeah.
Prior to the 50 years, it was 20 years or 25 years.
The earliest copyright statutes, which were about 300 or 400 years ago, the statutes of Anne in the UK, the earliest common copyright statute, which is the statute of Anne in the UK, it allowed for 14 years renewable once, so between 14 and 28 years. And it's worth pointing out that that was, I think, about 400 years ago. So since then, the rate at which culture changes and profitability of works go downhill has accelerated dramatically, and yet copyright length keeps getting longer and longer and longer. The original understanding, the original philosophy behind setting the Berne Convention the way it was, as lively artist plus 50 years, was, I think, based on the idea that after the artist died, he wanted to be able to support his family. Because it would have been, they would have been thinking of men. But I mean, it's even that standard is conspicuously archaic in the sense that they're thinking about a time when, well, the guy dies, so obviously his wife has to be provided for the next 30 or 40 years, and his kids have to be provided for because, I mean, basically you're harkening back to a time period where women didn't work and where financial structures were a lot different than they were today. So essentially, I would say that even the lively artist is conspicuously archaic, particularly when you look at the profitability of songs and how they tend to go down quickly. The Pirate Party in Sweden advocates for a single copyright term length of 5 years, which might be a little bit short, but there was also a proposal floated by a Republican think tank in the US that copyright should be for, I think, 10 or 12-year terms, renewable, but that each renewal should be more expensive and should be based on the profitability of the work. So essentially, what they're talking about is that if you want to extend the copyright out, you have to keep paying and keep paying and keep paying, so that works that are no longer profitable will basically flow into the public domain instead of remaining under protection for no conceivable reason. So that got floated by a Republican committee, by a Republican think tank, in January or February this year, and about 24 hours later, the guy that put that proposal out there was fired, because I think they got a lot of angry calls from the copyright, from the rights holding industries in the U.S. But I mean, the proposals are out there. It's just there's a whole lot of political obstacles to getting them passed, obviously.
So I would say that a lot of what you've mentioned today is really focusing on the music industry.
Sure.
But when you're looking at visual artists, or people who would be creating for the purpose of graphic design,
sure.
Prolonged protection for them is the only viable way, and making it more expensive for the amateur to ensure that their works are protected is kind of important. And if you look at visual artists, their works aren't worth anything till they're dead anyway.
Well, copyright protection, I certainly agree that copyright protection shouldn't be, yeah, it shouldn't be, it should be free from the outset, certainly. And I'm not sure that I endorse the proposal that the Republican think tank came out with just for that reason, because I'm not sure that you want to start making people pay. But I do want to mention, in terms of other media, I have been focused a lot on music because that's sort of where the debate is centered. But it is just as applicable to people that work in graphic design, to people that work in film, people that work in television. I want to mention a few things. One is that profitability on films tends to drop out after, I think it's 2 years. It tends to be the average profitability of a film. It's in my paper, but it's not in my speech. No, it's not. Oh well. It's about 2 years, and television's about the same. In terms of graphic designers, that's true, but also you could make the flip side argument that there needs to be greater protection for derivative works, and that graphic designers are the people who tend to work a lot with prior designs and images, so that they are the ones that tend to be hit hard by overly stringent interpretations of the exceptions to copyright or derivative works.
That was probably less so in Canada.
That they're, yeah, that's true.
In Canada, we have fair dealing, which allows someone to take a copyrighted piece of work and to take pieces of it. We talked about it. You can take a chunk of it without actually violating the copyright. And if you're looking at people who are involved more in visual arts, to prove that you've taken a substantial portion of a work is near impossible.
Yeah.
And it would be a litigation battle. It would bankrupt the poor artist, and it would only be at the hands of a big corporation if something like that would happen. But for the most part, you can get away with derivative art. It's very easy to show that you have copyright in some sort of new work, as long as you're talking, in any work, then it's a matter of who has copyright in it first. That's a battle. But I think as visual artists, you can get away with much more.
Sure, in Canada.
In the United States, it's the same.
Well, Shepard Fairey got sued successfully when he produced the Obama Hope poster.
That's substantial too.
I
understand. It's too bad because that was great.
But the original photographer didn't. First of all, the original photographer didn't recognize it when he first saw it. It was AP that went back and tracked it down. But also the Shepard Fairey example. I would say that that's completely transformative use. I would say that absolutely should be protected as fair use or fair dealing. I mean, do people here know the reference that I'm talking about? So in the 2000, the Obama Hope and Change posters, where Obama's face was turned into red, white, and blue. So that was based on an AP image by a particular photographer. And Shepard Fairey, who was the artist that made that, essentially just went to Google Images, grabbed the picture, played around with it, and released it. I think he just sent it to the Obama campaign. I think he definitely didn't monetize it.
Later.
Sure. But I'd be interested in hearing people's opinion on that particular work, because I think probably most people have seen it. You've seen the photo, well, you maybe haven't seen the photograph, but you can imagine it was just a regular photograph of Obama at a press conference. Do you think that in that kind of situation, the artist should there be a licensing requirement for that kind of a situation?
Especially when it's...
I would say that I guess he's transformed it into something that person who took that photo could never have imagined it to be.
Sure.
So it's, to me, they're two different things.
Yeah, it's a totally different work. And I don't know, man, this is just my first thought on it, but the fact that it's an image of someone who's a public person, to me even lessens the kind of any need for copyright over the image, because there's so many of that. That image with only slight difference, like you said, the photographer himself didn't recognize it because there's just thousands of these. And so it's, to me, I have a hard time with copyright of images of public individuals in public spaces to start with. I think it's quite strange.
It sounds like a public person test.
Yeah,
sure.
Yeah, absolutely.
I don't know, I'm kind of split here because I get the visual thing, right, and making a new image. I bet that on the other hand, my dad's a photographer, so this is that's a hard part when you know both sides of it.
When you go to create kind of posters like that, it's if you don't have a good image to start with, that poster's never going to happen.
Yeah, completely.
So it's if you can't find a good piece of wood to make your sculpture.
Sure.
So if you stole a piece of wood off of someone's property.
I guess if I was in front of that argument prior to being sued, my question would have been, did he take the picture and draw over it, or did he look at it?
Oh no, it was done through Photoshop.
Right.
So he definitely didn't look at it and create something new based on that.
He traced it over.
Yeah, he switched the colors around and the shading of it.
Yeah.
So no, it was completely done over that.
And what do you think about the Obama economy program?
Sorry?
Obama.me. You seen that?
No.
You can upload your own pictures with
Oh yeah.
Do it yourself.
I mean that's so I don't think there would be copyright problems there. Presumably you're doing it with your own photos.
Right.
So presumably there's no copyright to that, and I'm sure that there's a waiver on the website. saying that they can't, saying that they're not responsible for anything. No, it's a parallel problem, I would say, in terms of content creation, in terms of where the copyright should be drawn, is in terms of copyright and characters. So this is something that I alluded to when I mentioned the issues with Coming Through the Rye, which was a sequel to Catcher in the Rye that was supposed to come out 3 or 4 years ago, and then it got delayed. I think it's out now. But essentially, it was a guy wrote about Holden Caulfield sort of escaping from a mental institution and running through New York again at the age of 60 or 70. It was apparently it was terrible. But regardless of the merit of the work, I mean, that sort of artistic dialogue is vital to the creative process in my mind. But there's also the question of licensing and creators' rights. So I'd be interested to see, should you be able to copyright characters, and where should you draw the line between what can and cannot be copyrighted?
Pride and Prejudice and Zombies is very well-selling book, right? But it's
Public domain.
exactly. It's only you can only do stuff like that because of the term it's over, right? So it's kind of interesting that I think that's direct evidence to show that if there were shorter term length, there would be a lot more sort of aspects in which people could be spurned creatively to make new things. What is that? It's basically it's a book that sort of introduces a zombie story into an existing novel, Pride and Prejudice, and so they use substantial portions of the text of the actual novel. I don't know if anyone here has read it. I haven't actually read it. Just seen it around. But they sort of introduced this, and they've since kind of there's been a bunch of different versions of the same idea. So a lot of old classic novels that are now the term length is over, so the public domain, have had these extra stories kind of projected on them and into them, and the books are either reprinted or I think Pride and Prejudice and Zombies was actually properly printed, put through a publishing house, and actually made money, whereas some of these will just be like e-books or whatever, usually introducing aliens or zombies or vampires into existing works.
I mean, fan fiction is another similar thing that you find on the internet, with people writing their own sequels to Harry Potter or whatever, or Star Wars. And there's issues of copyright in the characters, copyright in the names, copyright in different aspects of the books.
Well, 50 Shades of Grey started as Twilight fan fiction. How about that? Apparently, I haven't read either of those either, but apparently 50 Shades of Grey started out as a fan fiction project involving characters from the Twilight series, and then they obviously changed it around enough so the public was no longer in violation of the publishing. I feel like 50 Shades of Grey came out before. I don't know. They didn't, but I'm not sure.
I mean, it's, again, it's about drawing that line between, in my mind, it's about going back to a purposive interpretation of copyright. Saying we're trying to spur creative creation. How do we design the regime so that it's best for, not necessarily the most profitable, but best for creative expression as a whole? We want to promote expressive content, and that means allowing artists to profit from their work. That means including through licensing, but that means doing so in a way that creates the maximum benefit to the broader expressive environment.
I wonder if someone could comment to my immediate sort of concern is just trying to share my artwork or get more of it out there.
Sure.
Facebook's a very good tool for sharing, but it's also the idea that I've lost the right to that image. Is that correct in that? And maybe just how one negotiates that.
Okay, I can't. Okay, so let me start with a broad disclaimer here, which is I was introduced as a lawyer. I have a law degree, but I'm not technically a lawyer because I don't practice in Canada. Well, I'm not a member of the Nova Scotia Barristers Society, so I'm not a lawyer. So that's the first thing. And I want to say that nothing that I tell you is legal advice because I'm not a lawyer in Canada. Well, I'm not a lawyer anywhere. But well,
I'm also not an architect.
I mean, different countries have different definitions of lawyers, which is why it varies. And because I travel, it becomes a strange thing. So according to the UK definition, I am a lawyer. So if I meet people from the UK, I can tell them I'm a lawyer, as long as I'm not in Canada. Anyway, so the point is that this isn't legal advice. But Sorry, your question was about.
Well, I guess
Do you
just
want me to answer it? I know the answer to your question.
yeah, like I guess there was a point that you brought up of like the song that they didn't make any money from it, but it was worth it to get the publicity, and so I just wonder if I'm very naive to use Facebook as a tool, or if that, I mean, I guess it's a personal choice or a risk, but just the understanding that if someone came to me and wanted to use something that they saw on my Facebook as their logo, or but do I even have rights or ownership to that image anymore, basically?
I'm not specifically familiar with Facebook's terms of service, but a lot of, generally speaking, these image sharing sites will print out incredibly broad terms of service. But the reason why they do it is not necessarily because Facebook wants to monetize your photos, but it's more because, or specifically monetize photos like that, but it's generally basically just so they won't get sued, so that they can, basically they're written in an overly broad way, trusting the fact that nobody reads them, because nobody reads them, I'm guessing.
Except they do, and every time they come out with a new clause that says, you know, we can use your images, somebody catches it and posts it on their wall and it goes viral.
Daniel might have the
To answer your question, when you sign up for Facebook, one of the terms and conditions, Mike was alluding to, is very broad. Pretty much says that by posting images on Facebook, you're granting everyone distribution rights to your photos, meaning they have the rights to download and to reproduce them without any recourse. So by posting your pictures, you're not giving up necessarily your copyright, but you're giving up your rights to prevent other people from distributing your work. So if I decide I really like your logo, and I decide I'm going to, download it and, make it my backdrop of my computer, then by you posting your images on Facebook, you're granting me the right to do that.
But basically everything on the internet is that. If I could take a screenshot of anything I see on the internet?
No, because you can't tell me to take it down, right? If I have my website, my business website, and I'm a graphic designer, I put up a bunch of samples I have, and then I find out that, that's now my header on Facebook, right? That you've taken from my website and then posted on Facebook, I can send you a cease and desist telling you to remove it or you're SOL. But if I find out that, I posted a picture to Facebook and you downloaded that picture and reproduced it somehow, and I send you a cease and desist, you can tell me to PFO because I took it from your Facebook and give you the right to.
Do you want to explain these lawyers' acronyms to people?
I was no discussion there. Is that
PFO is please fuck off.
okay?
Cease and desist letter. Right, so I went.
I checked,
But we're running short on time.
No,
Sure, are we?
If you have a question, you can ask me about that.
Coming back to what was mentioned earlier, you probably would be wise to watermark.
Yeah, it's actually a good it's a good marketing
Yeah.
to put your watermark on, that people know where it came from and they can view.
And then at least if somebody steals it and puts it in the magazine, you know they took all this lot of time in Photoshop and take that watermark out.
Also, you keep it lower resolution so you can't, it's not printable.
All very good.
So instead of being a worry, it's opportunity to market.
Always find ways around like copyright laws so that you can distribute your work through the internet, which is through music and printed. Like the internet is the only way people learn about things and that we can share things. So if we start denying the utility of that, you won't go anywhere. Right? So it's interesting with music. I find that copyright laws and they're just basically backwards. In even sharing, for example, you have like an historical song or something where, say, a folk artist dies tomorrow, and his song is protected, and you want to live stream a concert where people want to honor him, and they don't have the rights to sing a song, and so we can't celebrate it anymore. And if you want to talk about incentivizing, you say, can incentivize his estate even, I guess, is that what you're trying to do after he dies, to push more records? Or if he's still around but not singing anymore, and you have other people wanting to sing his songs, you can still profit off of his music. If there are younger people singing his songs and you're letting them do that, because it just seems so backwards to me. So I'd just like to see people try to find ways to keep sharing over the internet and growing that way instead of being afraid.
Well, the folk example is a good one because obviously borrowing is a rich part of folk music. There's a great quote from Woody Guthrie where he said, don't worry about tunes. Take a tune, sing high when they sing low, sing fast when they sing slow, and you've got a new tune. And in fact, Woody Guthrie's signature hit, This Land Is My Land, was a slightly adapted version of The World's on Fire by the Carter Family, which is a melody that they themselves borrowed from Oh My Loving Brother, which is a traditional Baptist gospel hymn. Ironically, Richmond Organization, which is a music publisher which claims copyright over The World's on Fire, is still filing lawsuits to prevent its use by other musicians.
You're not gonna get anywhere with fighting other people using music. Especially this book is just a really good example of what is now being, like that sort of practice is what is being used in other genres now with sampling, but it's something that's been done forever, and that's how music has become that kind of genre. And if you don't let people do it, like we're gonna run out of tunes, right? You ran out of tunes a long time ago if you're worried about people ripping each other off.
Sure.
Again, there's the performance versus mechanical. It's using someone's song versus taking an actual sample of that recording and something else. It's very specific.
But I think even between Daniel and Aaron, saying, well, if you said Martin Luther King's speech, would you be violating copyright? Well, yeah. Like those kinds of questions, the fact that we don't really know the answer to those questions, and these are lawyers asking each other that, we think about with artists, there's this fear about even interpreting, or there's a real gray area when it comes outside of sampling, and you're just interpreting things and what you can do and you get away with, when you don't have a lot to start with in the first place, and you risk losing everything. You're not going to create, and it's anti-creative. And
I do want to mention that that kind of clarity is, I think that's probably something that everyone in the room can agree on, which is the need for greater clarity within copyright law. Clarity itself is a cardinal principle of freedom of expression legislation, where if you're going to create any kind of legislation that infringes on people's expression, it's very important that it be clear, because any kind of fuzzy line leads people to steer well clear of it, which can lead to a sort of chilling effect where artists are afraid to create content or afraid to even venture into the area if there isn't a clear legal standard. So I think that the lack of clarity, both within these emerging areas of law and internationally, the differences that you get country to country are really probably a very important issue to solve, in my mind, in terms of the global copyright regime.
I just have one more question. So as, let's say copyright's redefined and we kind of move towards this division of where it applies and where it doesn't, we kind of have Creative Commons and we have one that isn't. And it seems like the preferred technology for large corporations to protect copyright would be something like digital rights management, which I think can be criticized for removing any kind of freedom of expression and really puts a large lock on it. So would that potentially lead to kind of a subdivision in culture where there's really two levels? There's kind of the free, everyone can have level, but then there's this corporate rights level of just kind of strict management. And do you see DRM as a problem within this landscape? Or is that a useful tool, do you think, to help if we can narrow in and say, this is where there should be copyright, DRM would be appropriate?
I mean, I see significant problems with DRM, but the picture that you just painted, where essentially copyright is protected in as far as you can physically protect it yourself. That's essentially eliminating copyright altogether and saying if you have the technical means to protect your work, then keep it protected. There's a number of reasons why that's problematic. One is that the point of copyright is essentially to protect artists and enable them to make a living. So this essentially turning it into a might makes right argument, where the people that have the resources can get the protection, and those that can't don't. That's going to be problematic because it's taking protection away from the people that need it most. More broadly, digital rights management can be problematic in that, well, first of all, it's completely ineffective. Because, I mean, there has never been a digital rights management regime created that has actually really effectively protected copyright. People always will find a way around it if you give people enough. The internet's a big place, and there's a lot of people with a lot of expertise on there who will always be willing to crack games, CDs, movies, just for the sake of doing it. Particularly when you look at the fact that one of the things that's driving piracy around the world is price imbalances from country to country. So if you look at purchasing power parity, a DVD in India will cost you the equivalent of about $635. It's something like $14 in actual prices, but according to when you take into currency valuations into account. It's a huge amount of money. So people in India, people in China can't afford to buy CDs, DVDs legally. And that's why when you look at a little bit of the industry statistics about the money that they're losing, they're assuming that all these people in India and China would actually be buying their music, when really it's placed completely out of their price range. So one of the issues in dealing with piracy as a global phenomenon is you're going to have billions of people that don't have a legal way to get this stuff, and they're going to find a way to do it. So essentially, I mean, there is a strong sense that sort of the horse has already left the barn on piracy, and that legislation needs to be brought up to code. So I see that we're just about out of time. I do want to pass around sort of or invite you guys to all sign up if you have a moment. Partly because, well, can I pass this around? Sure. I mean, you don't have to, but we do a fair amount of work on freedom of expression issues generally, if people are interested in that. I'd like to add you guys to the Center for Law and Democracy mailing list to keep you informed about events that we're having. We won't spam you. We don't send out emails more than once every 2 or 3 times a month, if that. But really, whenever we have a release or a product or an event, we send something out. And I want to thank everybody for coming and participating in what I think was a really great discussion on copyright law. And the turnout was much better than I had anticipated. And people brought a lot of strong ideas to the table, and it was a great discussion for me to participate in. So I want to thank you guys all for coming out.
Thanks, Mike.
I just wanted to quickly put a face to a name. The Hub was very graciously hosting my box out there for collecting jeans, and having an art show in May based on the denim industry in my birth country of Lesotho, which is a small African nation. So it's certainly I'm dealing with a lot of law issues, and the show will be in May. I have to change the dates out there, but anyway, I'll keep you posted at the Hub.
As am I. Thank you, Mike. I gotta run.
Yeah. Thanks, Mike. Yeah. See you later.
We'll play tomorrow?
Yeah.
What time?
I'll send an email.
Okay.
All right, cool.
How are you? Good.
I guess I should have passed this around.
No, it's getting
You're going to bring it out here?
All right, sure.
So, do you produce music for?
Do I have you on our?
No, Katie invited me, so
Um,
that's how I heard about
Any
it.
guys in town like that, or?
Yeah.
There's methods you need to
Sorry.
methods. If you have a particular set of notes that you play, or if you're involved in that.
Okay, so you can copyright.
The only reason why I'm interested is that
You can't really copyright just an idea. It has to sort of be set down or a concept. Oh, thanks.
But like a particular set of notes.
Cheers. Thanks.
Yeah, I was really lucky.
You have like all sorts of coding or all those things that create processes. It's just a basically derivative works. So
right now,
So you're talking about like a particular style.
for example, what we might do
really
is
you do much more.
website.
So, for example, like that's how Quentin Tarantino gets with.